Good morning, ladies and gentlemen. And thank you, first of all, Scott, for leading us through the annual meeting. And I would like to welcome you all to today's meeting of the House of Delegates, January 30th, 2021. I want to remind all of you that the meeting is being recorded and the meeting will be shared with members of our association, members of the public, and the media. Please be also aware that you will be muted unless selected by the chair to speak. As has been done in the earlier meeting today, we will be using the raised hand feature, which we've all grown accustomed to over the last 9 months or so. If you are selected to speak, I remind you, identify yourselves, identify your affiliation. Please speak only once. Keep your remarks to 3 minutes or less. Any questions should be directed to me as chair. And with respect to reports, I want to make sure that we are all aware that if you would like to speak, again, use the raise hand feature. After discussion, you'll be asked to take a poll. You will vote aye, nay, or abstain. If you abstain and if you want to have your abstention recorded, I'm going to ask you that you not use the Q&A feature or that you not use the chat feature, but that you send an email to Tom Richards. And Tom, if you are on the line, can you please give your email address? And again, this is for sending your name if in fact you want your abstention recorded. If you don't care about that, then don't worry about it. All right, I believe Tom just put into the chat his email address. You can all see it. I'm looking at it now, trichards@nysba.org. Again, if you want to have your abstention recorded, use that feature. All right. Our first order of business on the agenda is the approval of the minutes of the November 7th, 2020 meeting. The minutes were circulated. All should have received them. I know that you all dutifully read them. And if there are no changes, then we will accept them as they were sent out to you. And I see Tom Richards, I'm going to ask that you assist me if there are any hands raised. I don't see any hands raised at this point. And that being the case, I'm going to accept the minutes as they have been prepared, drafted, and sent out to the members. All right, our next item is report of the nominating committee, and that will be provided by past president Sharon Stern Gersman.
Thank you, Mr. Chair. On behalf of the nominating committee, I would like to submit nominations for officers and members at large of the executive committee. These nominations were made in compliance with association guidelines and procedures. Beginning in June, we issued requests for candidate applications to all NYSBA members. During the fall, we evaluated candidates' applications. In September and November, we interviewed the candidates at meetings that were held virtually with a number of safeguards and procedures that had been approved by the nominating committee at a short Zoom meeting that we held in August. In November, we voted on the candidates and prepared our committee's report. First, I'd like to thank all of the members of the nominating committee and all of the candidates who under very trying times gave their all, gave their attention to a long nominating committee meeting, particularly in November, and did so with great professionalism and in the best interests of the association. I would like now to submit the following nominations for officers and members at large of the executive committee. For President-elect, Sherry Levin Wallach of White Plains. For Secretary, Taya R. Grays of New York City. For treasurer, Dominic Napolitano of Brooklyn. For district vice presidents from the 1st District, Diana Sen of New York City and Michael McNamara of New York City. For the 2nd District, Amy L. Richter of Brooklyn. For the 3rd District, Robert T. Schofield IV of Albany. For the 4th District, Nancy Shoketti of Saratoga Springs. For the 5th District, Jean Marie Westlake of East Syracuse. For the 6th District, Richard C. Lewis of Binghamton. For the 7th District, Mark J. Moretti of Rochester. For the 8th District, Kathleen M. Sweet of Buffalo. For the 9th District, Adam Seiden of Mount Vernon. For the 10th District, Donna England of Center Reach. For the 11th District, David Louis Cohn of Kew Gardens. For the 12th District, Michael A. Marinaccio of White Plains. For the 13th District, Orrin J. Cohn of Staten Island. For executive committee members at large, Sandra Rivera of Albany, Thomas J. Maroney of New York City, Lamar Jackson of Rochester for the diversity seat, and Simeon H. Baum of New York City for the section seat. This concludes my report on behalf of the nominating committee.
Thank you, Madam Chair and Madam Past President. Is there a motion to close the nominations?
So moved.
It's been properly moved. Is there a second?
Second.
It's been moved and seconded. And I would ask that a poll be put up. All right, the motion carries at 97%. Thank you all. I have no other nominations before me, so I will entertain a motion to direct that a single unanimous ballot be cast for the election of officers and members at large, as were just reported on.
Mr. Chair, I move that a single unanimous ballot be cast by the secretary for the election of officers and for executive committee members at large.
Thank you. Is there a second?
Second.
It's been properly moved and seconded. I will ask that a poll be put up. The motion carries at 96%. Thank you, Madam Chair, for your report, and congratulations to all of the newly elected officers. I look forward to working with all of you in the coming year.
Mr. Chair, and my congratulations to President-elect designee Wallach and all of the other officers and members of the executive committee.
Thank you. We are all standing and giving a round of applause. The new officers, you just can't hear us as well as usual. But I will. All right. Thank you. And that completes that item. Now I want to move to the next item, which is a report of the Committee of the New York State Bar Association Facilities. And I'm going to call on, and this is just an information report. As you all know, we had a lengthy meeting just last week where we had enough time for Q&A. And the reason we had that meeting last week is because this week we knew we were not going to have that opportunity. But at the same time, I do want to make sure that everyone has the opportunity to ask any questions or comments that you may have after this report and after the meeting last week. So what I want to do is give you the address now that you can use, and that is dmiranda@nysba.org. You can send any questions or comments that you have after this presentation today, and I am sure that they will be responded in a timely fashion and in due course. All right, today again will be a brief meeting, and I will call upon our distinguished Facilities Committee chairs, David Miranda, and also members Michael McNamara and Sandra Rivera. David?
Thank you, Mr. Chair. Good morning, everyone. I want to thank all who joined us last Saturday for our 2.5-hour informational session on our facilities lease and the cost of renting and maintaining 1 Elk Street. We attempted to share as much information as we could, listen to concerns that were shared, and answer all of the very important questions that were raised. Since that meeting, I've received many follow-up comments and questions, and we've attempted to respond the best we can to all inquiries. From the feedback I received following the presentation, there appears to be a general consensus that it was my least funny stand-up routine. So we're not going to go over what was said last week. I want to give you a brief update on developments since then. Since last Saturday, leaders of both the association and the foundation, beyond the negotiation teams, have met at length and discussed the facilities lease and related issues, as well as common goals and concerns of our two organizations. We talked about the fiscal realities of maintaining 1 Elk Street and agreed that both organizations need to look at these issues together and move forward together. We previously shared with the foundation substantial financial information and agreed that foundation leadership could share that information with the foundation board when they meet today. We also provided additional financial data in response to questions that were raised, and it is our intention to provide as much information as necessary for foundation leaders to understand the fiscal realities so that they can join us in making the best possible decision going forward. We agreed to continue discussions as often as necessary for as long as it takes to work through these very serious and important issues. Our negotiating team has also sought the assistance of our finance committee as we look at the costs to the association of remaining at 1 Elk Street. In light of his role as immediate past president of the New York Bar Foundation, NYSBA Finance Committee Chair John Gross recused himself from all participation in deliberations pertaining to the current lease and lease negotiations. Past President Michael Miller has graciously stepped into the role of acting finance chair for lease-related issues. And over the last week, the Finance Committee has met multiple times over many hours to review and analyze the financial issues related to the cost of our facilities lease at 1 Elk Street. Our negotiating team, consisting of me, Sandra Rivera of Albany, and Michael McNamara of New York City, has also met multiple times over many hours, investigating our dual potential paths for the association: the cost of staying at 1 Elk Street and the cost if we were to seek other space in downtown Albany. Fortunately for us, Sandra Rivera is also a member of our association's finance committee, and I'm going to turn this over to Sandra to report on the work and findings of our finance committee as it pertains to the lease.
Thank you, David. Good morning. And I just want to thank you, David, for your leadership, and Michael for all of your time and work on the negotiation team. In addition, I'd especially like to thank my fellow members of the Finance Committee, especially Michael Miller, regarding the diligent and thorough work that you've undertaken over the last several weeks, reviewing various financial aspects related to the lease review. And I thank you in advance for your continued work as we further review anticipated costs to the association of renting and maintaining 1 Elk Street over 10 years, assuming similar terms, as well as with leasing space at another location in the city of Albany, as David has mentioned. Also, as David has mentioned, the Finance Committees met on January 22nd for the specific purpose of reviewing the purpose of each of the State Bar Association's reserve funds and to determine whether it would be proper and permissible to use such funds for construction, substantial capital improvements, or renovations at 1 Elk Street. The committee unanimously agreed that the use of these funds for such purposes would be outside the scope of permitted uses and/or would otherwise be inappropriate. We met again on January 28th to review and discuss a number of issues associated with the lease. To list what we reviewed are relevant costs associated with the current lease at 1 Elk Street since 2010, the anticipated cost to the association of renting and maintaining 1 Elk Street over the next 10 years if the association enters into a lease with similar terms, including cost of renovations. We also looked at the cost to the association of providing services free of charge to cover the foundation's operational expenses since 2010, and the anticipated cost to the association of providing similar free of charge services to the foundation over the next 10 years. Additionally, we reviewed the arrangement with the foundation regarding reimbursement for 2 salaries and the amount of grants the association has received annually from the foundation over the past 10 years. So now I'm going to provide you a little more detail regarding those things. So Tom, if you could show the chart related to the current lease costs since 2010. So based upon a comprehensive review of all the relevant information, the committee concluded that since 2010, the cost to the association of maintaining the facility at 1 Elk has totaled $9,948,799, or an average $994,880 per year. As you can see in the chart, this amount includes rent, insurance, maintenance, and taxes. And you'll see at the end, we have the 2010, and then all the way at the right, we see 2020. And those items are listed out. We also looked at these numbers and projected over the costs over the next 10 years. And the committee projects that over the next 10 years, the cost to the association of maintaining the facility at 1 Elk Street would conservatively be in the range of $16,131,000 to $19 million. This range includes the estimated cost of renovation with phase 1 costs of $2.6 million and could possibly exceed $6 million for the full renovation costs. I believe in your materials, and also last Saturday at David's informational session, he walked through some of those renovation costs. So going forward, the Finance Committee will be reviewing and assessing the cost of moving to and renting facility space in downtown Albany so that the full cost comparison can be made. Now I'm going to go into the State Bar Services and support to the New York Bar Foundation. Tom, if you can show the other slide, thank you. So as I mentioned, there's other costs that the State Bar is contributing in addition to the cost to rent and maintain 1 Elk Street. So additionally, the committee reviewed the services provided by the association to the foundation over the past 10 years. And these costs are exclusive of the salaries and fringe benefits paid to or for the benefit of the staff members pursuant to a separate agreement between the association and the foundation. So separate from those costs associated with the salaries, we have costs that are either paid directly by the association or provided by the association staff to the foundation. And the committee has reviewed, and over the past 10 years, the cost is $4,016,409, or on average $401,640 per year. And again, as you'll see, we have the numbers going from 2010 to 2020. And last year, the annual amount for such services conservatively totaled about $410,577. Additionally, the New York Bar Foundation, we looked at the grants from the New York Bar Foundation to the State Bar, and the amount of grants the association has received annually from the foundation over the past 10 years relative to the amounts the association pays in rent, maintenance, and services to the foundation has been declining to less than $40,000 in 2020. So our negotiation team will continue to work towards gathering the necessary information for all of us to determine the best path forward for the association. In the weeks ahead, we welcome your thoughts and questions, and we'll continue to report to you on the status of our negotiations. Thank you. I'll hand it back to you, Andrew. Thank you.
You. And David, if there's nothing more, we will move on to the next item. Again, this was largely just informational. I will say that the committee has been hard at work and has assured me that they will be providing more information as we go. Again, I gave the address. If you have any questions or comments, to send them to dmiranda@nysba.org. We do not have time to go into lengthy Q&A today as we did 2 weeks ago. Thank you, David. Thank you, Michael. Thank you, Sandra. And we look forward to hearing more of your information to be provided in your continuing reports in this regard. All right. Next item is a report on the committee, report and recommendations of the Committee on Immigration and Representation, and that will be by Hassan Shafagula.
Yep. Good morning. My name is Hassan Shafiqullah. I'm the attorney in charge of the Immigration Law Unit at the Legal Aid Society, and I'm the chair of the Committee on Immigration Representation. I'm joining you this morning to urge you to adopt a resolution calling for an independent Article I immigration court, and also to adopt a report issued in October of last year by the New York City Bar Association. That report was issued jointly by its Immigration and Nationality Law Committee, of which I'm also a member, together with its task force on the rule of law and its task force on the independence of lawyers and judges. The City Bar Report provides an excellent overview of the problems with the immigration court system, and I'd like to take a moment to highlight just a few of those problems. Currently, the immigration court system is not part of the federal judiciary. It is not an Article III court, and instead it's an administrative body that's housed within the executive branch, and specifically within the Department of Justice. And of course, the Department of Justice is the highest law enforcement agency in the country and headed by the Attorney General. The immigration court system is called the Executive Office for Immigration Review, or EOIR, and it has two parts. The main part is the Immigration Trial Court across the country, and above it, the Board of Immigration Appeals, or the BIA, which is its appellate body. The immigration judges and the BIA members all report up directly to the Attorney General, who can intervene in individual cases, as we've seen repeatedly over the last 4 years. Denials by either the BIA or by the Attorney General can be appealed up in some circumstances to the Federal Circuit Courts of Appeals through a petition for review. The City Bar Report details how the Trump administration in particular systematically undermined the judicial independence of immigration judges and BIA members in a variety of ways. Most directly, the EOIR politicized personnel decisions. They expanded the BIA and stacked it with judges who had the highest asylum denial rates. The average denial rates among new BIA members was 92% versus a national average of just over 60%. They also sought to remove immigrant-friendly BIA members by offering buyouts or early retirement incentives with the hope of replacing them with less friendly members. EOIR created a new Office of Policy that restricted immigration judges with new performance metrics. Judges are supposed to decide 700 cases a year, which is about 3 per business day. That brisk pace that these quotas would require ignores the complexity of immigration cases. And it's much easier and quicker to just deny a case than to write out a reasoned decision approving it and granting immigration relief. A high denial rate would allow a judge to meet their annual quota, and meeting your quota is necessary to get just a satisfactory rating on your employment evaluation. To make sure that judges are aware of how they're doing on their quota, their computers now have this dashboard that pops up each morning, which shows, are you in the green or are you in the red? If you're red, that means you haven't been deciding enough cases quickly enough. They also limited training for immigration judges. Immigration law is constantly changing and evolving. In the past, EOIR offered regular and robust training for its judges and BIA members, but in the last 4 years, there were considerably fewer trainings, and the ones they did provide emphasized deportation over granting immigration relief. They also reassigned cases away from judges who were seen as too lenient. The matter of Castro Tomb is the most prominent example, and that's highlighted in the report. They've also attempted to silence judges. They prohibited judges from speaking publicly, even just addressing law school classes, which is something that had been going on for decades. But they also broke the judges union. The National Association of Immigration Judges was decertified. The report says that the attempt to decertify them was unsuccessful, but upon rehearing, the union busting effort was successful, and they were decertified on November 2nd, and that happened after the report was issued. The administration also sought to bypass the normal appeals process in at least 2 ways. One, both Attorneys General Sessions and later Barr each certified immigration decisions to themselves, overturning decades of precedent in the process. And they also, in a new development, they designated the head of EOIR to decide cases himself. This was when McHenry was the head, if the BIA hadn't decided the case within 90 days of the appeal reaching the BIA. The head of EOIR has always, in the past, been a purely administrative position, focused on the operation of the courts and the BIA, and was never a final arbiter of appeals. And they did several things to restrict immigration judges' ability to manage their own dockets. And these were largely decisions by Attorney General Sessions. First, they limited what's called administrative closure, which is basically marking a case off calendar in immigration court. And you might want to mark a case off calendar for various reasons. Sometimes it's in the interest of the non-citizen, sometimes it's in the interest of the government. And they said, well, we don't need administrative closure because the judges can grant long adjournments, or what are called continuances. Then came a decision limiting continuances, saying you don't really need those because you can use a docket management tool called the status docket. And then they issued a memo limiting the status docket. They also limited the judge's ability to terminate cases on their docket, even for things like applying for a green card. If the person before you is trying to adjust their status and trying to get an immigrant visa or a green card, in the past, the judge could terminate if U.S. Citizenship and Immigration Services, the immigration agency, could decide that case, which generally they can. It doesn't make sense to keep cases on the judge's docket if an administrative agency like USCIS could handle that case. And the immigration courts have a backlog of over 1 million pending cases right now. So to limit the judge's ability to terminate cases for things that could easily and I think more properly be handled by a sister agency like USCIS just makes no sense. Those are procedural changes, but they also restricted immigrants' substantive rights through various attorney general opinions. The matter of AB is the most high-profile one that limited the ability of domestic violence survivors to seek asylum in this country. There were other decisions limiting the ability to seek safe haven in this country if you were fleeing gang violence in your home country. I mean, there's a whole range of things that they did to undermine decades of settled asylum jurisprudence. So all these policies undermine the integrity of the immigration court system and the public's confidence in this court process. And importantly, they demonstrate the inherent conflict of interest in housing a judicial adjudicatory body, such as EOIR, within the Department of Justice, a federal agency that's primarily charged with law enforcement, not with the neutral fact-finding. Now, I recognize we do have a change in administration, but what the report describes is an inherent unfairness in having a prosecuting agency also serve as the fact-finder. The conflict remains regardless of who sits in the White House and regardless of however fair they may intend to be. No administration should have the authority to issue such policies and decisions that undermine the integrity of the immigration court process and undermine the public's confidence in the system. I note that the state bar has in the past supported efforts to increase fairness and due process in other administrative hearing contexts where there's been a similar conflict of interest. Just over a decade ago, in 2000, the House of Delegates adopted an October 99 report by the State Bar's Special Committee on Administrative Adjudication regarding similar due process concerns with 4 state administrative agencies. Those were the Department of Motor Vehicles, the Department of Family Assistance, the Department of Health and Environmental Conservation, and the Workers' Compensation Board. That report found that the executive agency officials' influence on the fact finders within each of those agencies was so pervasive that it prevented agency hearings from being truly fair and impartial. And that report called for the creation of an independent hearing process at each of those agencies. And now, a decade later, we're considering the same sort of conflict, but in the immigration court context. On behalf of the Committee on Immigration Representation, I respectfully urge the House of Delegates to adopt our proposed resolution calling for an independent Article I immigration court to be created by Congress, and also for you to adopt the City Bar's thorough report detailing these problems. I'm pleased to note that the State Bar's Committee on Legal Aid has submitted a comment in favor of an independent Article I immigration court, and the Erie County Bar Association has submitted a comment in favor of not only an independent immigration court, but also in favor of adopting the City Bar's report. So thank you for your consideration, and I'm happy to address any comments or questions that you may have.
Thank you, Chair. Now I will entertain a motion to approve the report. Is there a motion?
So moved.
The motion has been moved. Is there a second?
Second.
Mr. Effman has seconded. Now I want to make everyone aware that the Executive Committee met yesterday and reviewed the report and recommendations of the committee and recommended approval. Now that being said, I will entertain discussion. I see 2 hands raised, one by past President Steve Younger and one by John Leo. Steve Younger's hand disappeared. Steve, if you are still interested, please raise your hand. Mr. Leo. Mr. Leo.
I'd actually raised my hand for the prior subject, which I would hope to speak at some point, but I just want to comment first, Hassan, thank you for your presentation. Through the good offices of the ABA, I had the privilege to be in one of the immigration courts in Southern California, just south of San Diego. And it was an eye-opening experience. And, you know, all I can say is any of us who can devote our pro bono efforts to helping, I understand one of these courts is located as far away from any lawyer in America other than one. The whole process was just extraordinary to me. The vast majority of people in the room had no lawyer whatsoever, and facing truly, you know, life-oriented decisions. And to believe that in this day and age, when we believe that, you know, our, you know, citizenship in America is part of our fundamental rights, that you can take rights like that away without a judge who has, you know, someone who reports to someone in the Justice Department, when actually the person who's the adversary is in the Justice Department as well, is just truly eye-opening. So I fully support the report.
That was a mistake for my hand raise, a computer problem. Sorry, folks.
Andrew, you're muted.
We're having some trouble with the raise hand feature. As Judge Leo just mentioned, he's having some issues. Please bear with us. We will navigate this just as well as we can. Now I'd like to call on Sherry Levin-Wallach, the newly elected president-elect.
Thank you, Mr. President-elect, and good morning, everybody. Sherry Levin-Wallach, Secretary of the Association. I'm also a member of the Immigration Representation Committee, and I just want to take a moment to commend this committee on its incredible amount of hard work. This committee stays on top of all of the issues affecting immigration representation. They are actively involved and work very hard, not only amongst themselves, but amongst the larger immigration representation community, in order to make sure that the rights of the individuals that are facing immigration issues in court are respected and maintained. I strongly endorse this report and encourage everybody on this meeting to please endorse this report. Thank you.
Thank you. I next want to call on past President Vincent Doyle. Vinny? Vinny, you have,
Yes.
oh,
Hi.
please.
Can you hear me now? Thank you, Andrew.
Yes, we can.
I just want to join in thanking the committee for this excellent report and bringing this important issue to our attention. And I would encourage the committee to consider, once this passes, asking the State Bar Committee on Legislative Priorities to make this a legislative priority in the federal realm. I think it's very appropriate that it be a top priority of the association to advocate for this. So thank you very much.
Thank you, past President Doyle. I see no other hands raised. So at this point, I believe that we can take a vote, and I will ask that a poll be put up. Please vote.
Close the poll in 5 seconds.
Poll will close in 5 seconds. Poll has closed. The motion carries overwhelmingly by 93%. To the chair of the committee, Hassan Shafagula, I want to thank you for your hard work. And on behalf of the entire House, please convey our appreciation to the members of your committee. Well done.
Thank you. Have a good morning.
Okay. Now I want to move to the next item on our agenda, which is item number 5, and that is a report and recommendations of the Committee on Mandated Representation, and that will be presented by past committee chair, Norm Effman. Norm, I believe you're with us. And if you unmute, please. Norm, if you unmute, please. You're good now.
A lot of people have requested I do quite the opposite, Mr. Brown, but that's okay.
I don't want to listen to those people discuss. We anxiously want to hear what you have to say.
Yeah, well, thank you, Chairman Brown, and good morning. It's still morning, and I've always actually enjoyed presenting before this body, and of course, virtually it's somewhat difficult. And in most situations, when I'm presenting on issues that are dear to me emotionally, and matters that I'm related to, such as parole reform or raising 18B rates. And so now I'm presenting on basically editing a document, somewhat drier than what I'm used to. And I was trying to look for some emotional link to what I'm about to do. So this is actually the 6th update of these documents. And in order to give some meaning to what this is all about, I thought about the history of the document, and I think it's important for this body to understand that it's not just another report that is sitting on a shelf somewhere and gathering dust. This really all stems from the 1962 Gideon decision of providing the right to counsel in criminal cases to people who can't afford their own lawyers. And New York State woke up sometime at the turn of the last century, around 2000, and realized that New York State is failing to meet its mandate to provide effective, constitutionally protected representation to people involved in the criminal justice system. I think that the New York City providers were absolutely stunned to find out some of the dark holes that existed throughout the state in our ability to provide competent, effective representation. Well, in 2004, past President Levin created a special committee. The actual name of the committee was somewhat difficult to remember, so I'll look at it. It's the Special Committee to Ensure Quality of Mandated Representation. And then President Levin made a brilliant decision. He appointed that individual we just saw on the screen, Vinnie Doyle, to act as chair of this committee. And Vince Doyle, showing his leadership there, which would result in his leadership of this association several years later, created the first document with a wonderful group of individuals putting together standards for mandated representation. And not only were they well recognized and approved by the House in April of 2005, but it resulted in the American Bar Association giving its Harrison Tweed Award in 2005 to the New York State Bar Association for basically its outstanding leadership in creating statewide standards for this type of representation. So this Bar Association is recognized by the ABA because of this product. The next major step in advancing the competency of attorneys in representing people who can't afford their own lawyers was the advent and creation in New York State of the Indigent Legal Service Office. And that office, run by Executive Director Bill Leahy, is charged with the responsibility of creating standards and ensuring quality representation for individuals, both family court and in criminal court, who are relying on the state to provide them counsel. One of the first things that they did, ILS, was to create standards for representation. And in doing so, they completely absorbed and footnoted and related to the standards produced by this association. So this became the backbone, the very skeleton of what is now a state agency saying, these are the standards you must comply with. And ultimately, this has teeth because ILS, for those of you who are not involved in indigent defense, and most of you are not, provides probably 50% of the revenue for counties to provide proper services to its citizens or to anyone charged with a crime or involved in family court in their jurisdictions. So with that amount of money, for example, the Hurl Herring lawsuit, which resulted in all 62 counties being funded by the state for the first time in our history, to the tune of $250 million over the next 2 more years to go on that project. So this is, our standards are incorporated by the entity that is ensuring quality representation throughout the state. So I am emotionally involved because this document changed the very world that we who provide these services live in. So before going any further and getting into the details of what we're doing, there are 2 edits that have resulted from people reviewing these materials. One by former President Claire Gutekunst, and I think it is, if you have your documents, I'm looking at, it's 1.7K, and there's the last line there. It should say, instead of counsel's request, it should say client's request. And that information was sent over for a request to edit to Kathy Baxter. So hopefully that will find its way into this resolution if it passes. I also note that, and you have before you in your materials, a letter of support from the entity I just mentioned, the Office of Indigent Legal Services, applauding our efforts here and also pointing out an edit that basically was a problem in reviewing the last document and carrying forth an error that occurred there. And that's simply a switch from a Roman numeral 3 to a Roman numeral 2 in one of the paragraphs noted in William Leahy's letter. And that was pointed out to the executive committee yesterday as well. And hopefully that too will be edited. It's an error that occurred when the document was updated back in 2015 and then not corrected in this edition. So now as to the actual requests for edits, most of the material here, they fall into two categories. You have a portion of the report dedicated to adding a whole new section dealing with parole representation and setting standards for those individuals, attorneys that are representing people involved in the parole process. And that's basically doing administrative appeals from denial of release, representing people at parole revocation hearings, and representing inmates in a facility who are granted parole and then face a hearing where that grant is going to be rescinded. So with respect to the mandated standards for parole representation, this is brand new stuff. Parole, as most of you have in this association, in this house know, has been the subject of two reports filed by the Special Task Force on Parole Reform, headed by Bill Russell and Seymour James. It has traction in the state, looking at parole reform as an important aspect of providing criminal justice in an area that has long been neglected. And therefore, we felt it necessary to provide standards for those individuals who are handling these matters almost exclusively on an assigned basis. So with respect to the standards for mandated parole representation, I want to acknowledge the work of Leah Nowatarski, who actually is on my staff and is an officer in the criminal justice section and soon to be leader of the mandated representation section. She's my primary parole advocate in Wyoming County. And Marty Crawford, who is employed by the New York State Defenders Association, who did those two individuals did the editing or creation of standards for parole representation. They basically set forth standards, and again, Mr. Leahy, in reviewing this, outlined the fact that that's the first time it's happened, and it's necessary, and it creates a bottom line as to what we should expect from people representing individuals facing incarceration or facing the denial of their ability to return to the community. With respect to the other section dealing with upgrading the standards themselves, most of the requests here are simply a cleanup, and this particular section was done by Attorney Malvina Nathanson, a former member of this House, and the chairman of the Committee on Mandated Representation, Bob Dean. This is their work, and I have reviewed it. Most changes involve simple cleanup of language and clarity of the position stated in each of the sections, but there are two sections that deserve some special comments and review. And they deal with, and I think it's 17K that Claire gave the edit on. And this particular section deals with the issues involving continued communication with an individual who has been convicted by plea or verdict and wants to appeal to normally the appellate division, and providing them with information as the process continues. And perhaps most importantly, also mandating that the standards here are to ensure that if there's a request for an appeal, that it be filed and more, and it's just as significantly that the request be followed up by the duty of the attorney to ensure that if the individual is without funds to retain private counsel for the appeal, that the application is made to the appropriate appellate division for assignment of counsel. It also deals with a responsibility that is part of the ethical responsibility of lawyers in criminal process that are involved in trials where there is an appeal, and that is to cooperate with the appellate counsel in providing that the successive attorney, the appellate attorney, with the file and the records that are necessary to perfect that appeal. This has been a problem for those involved in the appellate world. And it's even, think about what happens on a criminal case where, for example, each of the parties, the prosecutor and defense attorney, maintain their own exhibits. They're not maintained by the court. In order to perfect the appeal, the courts will want to see the exhibits. If you as an appellate attorney don't have the cooperation of trial counsel in getting those exhibits, which are in that lawyer's possession, it just stops the appeal process from going forward. So that's an important aspect of the new mandates, setting standards, ensuring that there's cooperation between trial and appellate counsel. The other aspect that is in here that has a significant change, I think it's I-10J, page 14, because some of these are numbered in your document. This deals with a new CPL change in the law. Very often in dealing with an appeal, the appellate attorney discovers an issue that is not properly the subject of what can be done on the appeal brief. That is, if it's not an issue that is on the record, if it's something that is outside the record, typically an allegation of ineffective assistance of trial counsel, but something outside the record. So you can't proceed with that issue in the appellate court. The only way you can proceed with that issue is by a motion under 440, which would be asking the trial court to reopen the matter based on some due process or new evidence issues. But in New York State, when you, as an assigned counsel, get an appeal, you're not paid to do a 440. You're only paid to do the appeal. So there was a breakdown in the system for those attorneys that found an issue, or in speaking with their client, which is also an important part of the standards, determined that there is a viable issue that cannot be addressed in the appeal. That attorney now, under the law, has the responsibility to go forward with the 440 motion. And as part of that, of course, if they're assigned, they can submit a voucher for that as well. So the new standards incorporate the new language of the CPL, showing that part of effective and mandated representation includes the review of issues, even if you're just the appellate attorney, that may be appropriate for 440 application, and to proceed with that. I think those are the important issues I wanted to address on this. Everything else, as I said, is primarily just fine-tuning the wordsmith aspect of editing. And with that, obviously I will answer any questions, but I will move that the resolution be adopted by the House.
The motion has been made. Is there a second? Is there a second on the motion? The motion has been seconded, I believe, by Sherry Levin-Wallach. And I want to, before we have discussion, I do want to say that the executive committee met and reviewed the report and recommendations yesterday and did recommend approval of the report and recommendations to the House. Now I will entertain discussion, and I will start with past President Sharon Stern-Gersman.
Thank you, Mr. Chair. And thank you, Mr. Effman, for your continued leadership on this and for tackling primarily this year the parole issues. I suspect that these changes were in the works for some time, probably predating the pandemic. And I'm just curious if the committee will continue to work, particularly in light of changes in these standards that may be necessary to cover virtual representation, where it is not possible for the attorney and client to be in physical contact with each other or near enough to each other to be able to consult in person, and standards that may be appropriate when appearing before virtual court.
I could respond to that. Thanks, Sharon. It's the particular world that we're living in now, virtual, has been the subject of consistent review and comments by not only mandated representation, but the criminal justice section is looking at it. Various other entities are looking at it, including New York State Defenders and Chief Defenders Association of New York. And Bob Dean is very much involved with that, who's presently chair of the section. And I think Leah Nowatarski is chair-elect, so that she too is involved in this. We are most concerned, and it's a criminal justice section matter as well, with a proposal coming out of the governor, and I think OCA, to continue virtual arraignments by amending section 182 of the CPL. And that is under close scrutiny and review right now by every one of those entities, including mandated representation. And yes, we will continue to work on that. Thank you.
Next, I want to call on Sherry Levin-Wallach.
Thank you, Mr. President-elect, and good morning again. Sherry Levin-Wallach, Secretary of the Association. I also sit on the Committee of Mandated Representation and have for many years. I want to also commend this committee on its incredible hard work that it's done, especially dealing with the issues that are facing mandated representation during this pandemic. These changes are important. They are necessary. Specifically, the parole aspect is very important. Our individuals, our fellow brothers and sisters who are facing issues on parole deserve this representation, and these standards will assist in making sure that they are getting the best representation that they can get. So I urge this body to support this resolution as well. Thank you very much to the committee and to Norm Effman for his wonderful presentation.
Thank you, Madam Secretary. Now I would like to call on David Cohen.
Morning, Mr. Chairman. Thank you. Norman, that was an excellent report, and I rise in support of this report. I am the Vice Chair of the Criminal Justice Section. I serve on the Executive Committee. I was Codes Counsel in the Assembly when ILS was created, so I am fully aware of how significant our report on the standards of mandated representation are. And just to highlight, even though Norman did not think it was the most important section, my office just got involved in an appeal of an 8-year-old case because no one notified the incarcerated defendant that his co-defendant's case had been reversed. And we were able to get that appeal reinstated. It was a successful appeal, and that individual is now released from his incarceration. So it is crucially important that these standards, especially contact with the defendant after his or her conviction, be enforced. And I applaud the committee on its work, and I urge that this report be adopted.
Thank you, David. I next want to call on Maria Matos. Maria, you have to unmute, please. Maria, please unmute. Please unmute.
I apologize.
Okay.
For that.
No problem. Thank you.
So I rise in support of this. This is long overdue, and I commend the members of the committee for putting it together. And that's all I wanted to add.
Thank you. Judge Leo, I see your hand raised again. I don't know if that's still malfunctioning on our end or your end, but I'm going to continue to call on you at the risk of overlooking you. If your hand is properly raised, you can speak now.
It's a malfunction on my end. I don't know what's happening. I'm sorry, everyone.
All right,
I
no, that's okay.
apologize.
That's okay. We're having some issues now and then, but that's not a problem. But your name may be the most used name before the meeting is over today. All right, I don't see any. Were there any other hands raised? I don't see any. That being the case, again, the motion has been made and properly seconded. We are prepared to take a vote. And I would ask that the poll be placed.
Seconds.
Okay, the polling is complete and the motion carries overwhelmingly with 96%. Thank you, Norm. Your presentations are always welcomed and well done. Thank you to you as past committee chair. And I want to convey to the entire committee the appreciation of the House, and I would ask that you carry that back to those members who are not on this call today. Thank you.
Done. Thank you, Mr. Chairman.
All right, next, I want to move on to the next item, and that is a report of the LGBTQ law section. That is our newest section, one that we're all very excited about. And we have today with us to make the presentation, Christopher Riano, who is the section chair. Christopher, welcome.
Thank you so much. I'm so excited to have a chance to speak to everybody today. And I want to just give a brief report about the incredible things that are happening with the section. And I encourage everybody, when you have a second, to go to the main website for NYSBA, as you can join our section right there. A pop-up comes right from the main webpage. And it's been incredible to really lead the newest section of the State Bar Association. From changing from committee to section, we already have hundreds of new members that have joined the section and have joined our work. And that explosive growth is really exciting to see. On top of that, we had an incredible annual meeting this past week. And I was so excited to see not just so many people join, but we had 5 both past, current, and future State Bar presidents with us, which is always a great thing to see. And the feedback was wonderful. With the hundreds of people we're now engaging from around the world, I just wanted to give everybody a brief view of the various different things that we have going on. So to invite people to come and join the great work that we have. One of the things that I'm very excited about is to carry on the tradition that we had from last year on our amicus work. As many people here are aware, we submitted an amicus brief at the United States Supreme Court on behalf of the entire Bar Association, and we continue to monitor other issues that are percolating both inside the courts of New York State, as well as federal courts, including the Supreme Court, federal courts around the country. We're actually right now looking at a particular case that may end up at the Supreme Court. If it does, I expect that the committee will be coming forward to want to do another amicus brief if that does end up being taken up by SCOTUS. Our membership committee is obviously very quickly attempting to engage with our now hundreds of new members. We just had some meetings this week. One of the things I'm particularly proud of is we've had a lot of student interest in the section's work. And we now are going to have, even within the greater membership work that we're doing, a student kind of subcommittee that's going to focus on ensuring that we're engaging with students at all of the law schools across the state. Our programming committee has already now met as well. They've come up with various CLEs as well as non-CLE related programming. I'm so excited to begin to share those with folks as the weeks unfold going forward. We're going to be doing a series in the Law Journal. We have now a LinkedIn page. There are other social media things that we're working on. Of course, one of the things I'm particularly excited about is our legislative work. We both have legislative work happening here in New York State, as well as the things that are changing in Washington, D.C. Very excited about the developments we have there, but there's things still to do, like the Equality Act and other things that will be coming up that we definitely are intending to continue to be engaged in. And as of yesterday, the senior section staff or senior section folks decided on awards that we're thinking about. And so I'm percolating that around. I'll have more to say shortly about what that will look like, and to bring that to the various folks to talk further about it. But it looks like we have an agreement, at least within the senior members of the section, so I'm very excited. It really is all, full speed ahead. I'm really excited to see that there's been so much engagement already. And I have to say, because I'd be remiss if I didn't, that I want to thank the staff of the New York State Bar Association. They have been incredible partners along the way, exceedingly helpful with the work that we're doing. It wouldn't be possible to do it without the number of people that have been helpful from the executive director on down. So with that, I'm happy to answer any questions that folks may have, but I did want to briefly bring everybody up to speed because we are the newest section of the State Bar, and I could not be happier with how things are going.
Great, thank you, Christopher. I attended the meeting that took place over the past week, and I can say it was filled with energy and enthusiasm. And I know that a lot of good things are going to be coming out of that section. So thank you, Christopher, for getting us off to such a great start. If there are any questions for Christopher, please let me know and I will call upon you and you can ask Christopher or make your comment. All right, I don't see any hands raised. Christopher, one thing I will say is you mentioned a lot, but one thing I don't think you mentioned is that anyone who's looking to join now and does join now, there's no cost.
That's correct.
So please take advantage of that. We do that for a reason. We've seen a lot of excitement about the section, and I know that with more members, it can do that much more. So please take the opportunity, join the section, support the section. It's our newest section. All right, Christopher, thank you very much for your presentation.
Thank you.
All right, next I want to go to item number 7. That's the report of the Committee on Communication and Publications. And that will be presented by Committee Chair and Professor Michael Fox.
Thank you, Mr. Chair. I appreciate this opportunity to report on the activities and accomplishments of the Committee on Communications and Publications. My term ends May 31st of this year, and since I don't believe we're going to have another report at the April House meeting, this is my last opportunity to address you as a committee chair. So just some brief background before I report on where we are. This journey started back in 2017 when then President Sharon Gerstmann created the Executive Committee Subcommittee on Publications and appointed me as chair with the charge to examine and report on the association's publications and communications with members. The subcommittee compiled a report with a goal toward reforming the association's publishing and communication activities, and that was subsequently adopted. Thereafter, this House created the committee as a standing committee of the association, and I thank past presidents Michael Miller and Hank Greenberg and current president Scott Carson for asking me to stay on as the first chair of the Committee on Communications and Publications. Over the last 4 years, we've addressed issues including the new association website and web services, our web services provider, increased social media presence for the association, advertising matters, consolidation and redesign of email and print communications to members, our new digital first publishing policy, and redesigns and revisions to both the State Bar Journal and the State Bar News. Now I'm pleased to report where we are, some of our successes, and several of our goals for this past year. The committee has 25 members, including myself and our vice chair, Kelly McNamee. We also have wonderful staff here at the State Bar Association. Susan DeSantis is on this call with us, or in this meeting with us. And in addition to Susan in the communications department, we also have Brendan Kennedy, Christian Nolan, and Brandon Vogel. In the publications department, we have Dan McMahon, and we have Kirsten Downer, Catherine Callista, and Naomi Pitts. I hope I'm not leaving anybody out, but I wanted to make sure that we recognize not only our members of the committee, but the dedicated work of the staff in both the publications department and the communications department. So what are we doing? Let's talk about what we're doing first on a daily basis. We are posting new stories on the State Bar Association homepage. These are stories that are written by staff writers, by freelancers, and by members. They're posted online first as part of our new digital first policy, where they're posted digitally. Now, not everything that appears in our print versions appears digital first, but we pick from articles that we think are going to be informative or interesting or entertaining for our members and non-members alike, so that we are out there as an association in the legal community and beyond, speaking to issues of importance or interest to both members and the public. We choose those articles for the homepage, and they have practical value. And again, those that do appear on the homepage appear in print also for the most part, but then we have additional articles and discussions that appear only in print. We're posting on social media, and we're going to talk more about that in a few minutes. But we have editorial responsibility for Twitter, Facebook, LinkedIn, Instagram, and YouTube posts for the State Bar Association. We mention NYSBA media articles of interest, CLE and section event promotions, and lighter posts to entertain our audience. Anybody who follows us on Facebook or Instagram, you're no doubt familiar that in addition to articles, we post cartoons or a joke or something else, just to engage our members and hopefully attract non-members to the association. We track NYSBA media mentions. When the State Bar Association or the NYSBA president or anybody in leadership is quoted or mentioned in a newspaper article, a blog, a radio or TV story, we post it on social media, and then we organize it into the NYSBA in the news. And then we post that on the website. They make up stories that are provided in the president's daily brief, which is circulated to the president and the officers on a daily basis, identifying when the State Bar or any of its members or leaders are mentioned in news articles or reports anywhere in the world. We track our work, so we keep track of every article, podcast, every content item through Google Analytics. And from there, we can measure on our content how we're performing, our email marketing, our social media, our homepage placements, click-throughs, open rates. We can track it all, so we can see how we're doing and we can manage and maneuver. And we facilitate member-to-member communications through the online communities. And for that, we allow members from sections and committees to interact with each other. Now, what are we doing every week? Hopefully you are familiar with the fact that we have our weekly e-blast update on the coronavirus and COVID-19. That comes out every Monday, and then throughout the week, we will update it as it's needed, if needed. The main purpose is to update members about the virtual courts, coronavirus task forces, gubernatorial executive orders, federal stimulus information. There are links to related CLEs that we may be offering and other content on the website. And that is constantly being updated. We also, and this is through the communications department, issue statements in the name of the president of the association. Statements issued in response to press inquiries. And if there are statements that are requested, say the subject of the death of a former NYSBA president, those are sent to press contacts. Sometimes statements are suggested by government affairs, a NYSBA task force or a NYSBA section. And we connect those particular reporters who are asking questions to either the State Bar president or another individual who has knowledge and the ability to speak to that issue on behalf of the association. We field general inquiries on legal questions that come in from news media all across the world. We have podcasts that we release on numerous digital platforms, and we have several podcasts, including the Miranda Mornings, hosted by David Miranda, and Gold Fox Non-Billable, hosted by myself and Sarah Gold. And in fact, when we look at how our digital platforms are doing in terms of podcasts, the months August and September 2020 were the most successful for Miranda Mornings, with 2,500 downloads combined. And October 2020 was the most successful month for Gold Fox Non-Billable, with approximately 250 downloads. And those podcasts are available across Spotify, Google Play, Apple iTunes podcast app, the State Bar website, and numerous other platforms. As needed, we issue news releases. installation of a new president, presentation of awards or other plans for a NYSBA event, CLE communications, etc. We provide those on an as-needed basis. We, of course, cover House of Delegates meetings, as well as task force meetings and hearings. And in fact, the communications department assists in speech writing for the president and president-elect because they have so many speeches they give at any given time and at numerous events throughout the day, the week, the month, and the year. We also edit and produce the State Bar Journal and the State Bar News. The committee oversees that work. The journal is currently published 9 times per year, and in 2021, that is going to be reduced to 6 times per year by monthly issues. And the journal, of course, features articles on law and legal issues. The State Bar News is published 3 times a year, and this year it will be dropping to 2 times for the year, and that focuses on news particularly about the State Bar Association. They both generate revenue through outside advertising, but the revenue does not pay for the cost of producing them. The association's general revenues cover the remaining expenses. And when we talk about the State Bar News and the State Bar Journal, both publications reach about 45,000 members for every issue. So a circulation of approximately 45,000, and that's around the world. Because of course, as you know, are well aware from our membership reports, about a quarter of our memberships from outside New York State. So we have broad reach. For example, in terms of successful issues, we've had well-read articles. For example, Reflections of a Former Law Clerk had 14,891 clicks. Lawrence Garba's, New York's first known COVID-19 case, reveals what he learned about attorney well-being from the virus, had 7,200 clicks. And The Juror Who Exchanged 7,000 Text Messages, well, that one didn't have 7,000 clicks, but it had 4,237. So we've had successful articles that have been published that have put us out there in the world in terms of discussion in legal circles. Now, in addition to that, I mentioned to you that we're on social media and we're also in print publication. I'm sure you're all well aware that the State Bar Association has had comments that have been issued about Attorney Rudolph Giuliani and different circumstances revolving his recent news activity. Our statements on Attorney Giuliani had 1.2 million page views and 400,000 impressions on Twitter, and they were by far our most clicked through, impressioned, and viewed articles thus far in the history of the State Bar Association. The Giuliani statements that have been issued were covered about 4 or 5 times in the New York Times, on CNN, NBC, CBS, Forbes, Newsweek, Politico, the New York Post, the Daily News, Washington Post, Wall Street Journal, NPR, Reuters, Associated Press, and multiple other news outlets across the country and the world. So just to show you how this policy has gotten us in terms of getting out there, communicating to both members and non-members, of course, with over 1 million page views, that's not just our members, 70,000 plus. We're reaching a broad audience in our efforts to speak on social media, print media, and electronic communications. On average, the State Bar Association's tweets are seen by about 400 to 500,000 people on a monthly basis. During annual meeting of last year, we set a record with more than 764,000 impressions. We have 18,000 Twitter followers, we have 10,000 plus Facebook likes, and we recently crossed 4,000 Instagram followers. Facebook remains our go-to for legal humor posts, stories about Ruth Bader Ginsburg, promoting CLE events, and other matters. So we are leveraging our social media presence to attract members and non-members alike. We have content emails that we produce, and hopefully you're aware of that. The NYSBA Weekly provides around Wednesday at 11 a.m., which was launched in 2018, extraordinarily helpful information on our different departments and offerings across the association. October 2020, we had an edition that highlighted a new ethics opinion, and that had a record high click rate of nearly 11%. We also send daily update emails for breaking news, including for coronavirus, as mentioned before, and we generally have open rates that are consistently 30 to 35%. And for those who understand about those click rates and open rates, that is a very good percentage, 30 to 35%. By comparison, a regular CLE message generally gets about 14% opening. In terms of the annual meeting, and everything that we're doing in 2020, or did in 2020, we're doing in 2021. So for historical comparison, in 2017, At the annual meeting, our coverage was limited to social media and articles in the March-April State Bar News, and that didn't reach members' mailboxes until late March, 2 months later. So in 2019, we posted several articles as annual meeting week occurred. In 2020, our team reported on events with articles posted on the same day on the website, and then NYSBA Weekly included additional coverage of the annual meeting. It becomes more timely and more useful, therefore, to our members, and hopefully in attracting non-members. So, for example, in 2020, for the Presidential Summit, Brandon Vogel live tweeted the event as Christian Nolan reported on it, and then within 2 hours of the program, we had an article live on the website, a press release containing highlights of the event, and a video of the event. An hour later, we had all member emails sent to the NYSBA members with the article and the video. And it was the same thing for the House of Delegates, and we're doing the same thing this year. So we're becoming timely, and that is one of the main goals. Today, information, if it's a day old, might as well be a year old. And so we're becoming more relevant and more current in our methods of communication and reporting out these articles of interest. In terms of press coverage, as already mentioned to you, CNN, Fox News, the Wall Street Journal, the New York Times, Law 360, the New York Post, the New York Daily News, and Bloomberg cover us on a regular basis. And those are not aspirations happening now, and it's continuing to happen. We have made the New York State Bar Association current and relevant for our members, and hopefully in attracting non-members. And then one final item that's not included in the report before you, but I'd be remiss if I didn't mention this. The committee also oversees NYSBA's book publishing arm in that publishing department that I mentioned to you before, in the publications department. As I hope you're aware, NYSBA publishes numerous well-regarded practice books, both in print and ebook form, and you can find them on the NYSBA website. This past summer, Dan McMahon, Catherine Callista, and Naomi Pitts of our publications department, together with attorney Mark Berman as the editor, compiled a book entitled Virtual Lawyering, a Practical Guide. It's a 312-page compilation of the work of no less than 35 authors from across our association. And the ebook was written and finalized in a total of just about 2 months, designed to inform and assist our members, as well as non-members, with virtual law practice during this pandemic and beyond. This is the kind of thing that NYSBA has the ability to put together and publish for the benefit of our members and the profession, because of the breadth and depth of our membership's knowledge and practice areas and the hard work of our staff. Our goals for 2021-22, we want to examine the ways that we can place NYSBA's communications even more prominently on the homepage of the State Bar website. We want to explore partnering and collaborating with the NYSBA sections and committees to encourage an increased presence on social media and in print and online to boost their presence and get their material out as well, because that's of great benefit to our members and to attracting non-members. And we will continue to update the NYSBA social media policy every couple of years to ensure that the policy has been widely distributed and remains current. With that, I will conclude the committee's report, Mr. Chair, with thanks to the committee vice chair, Kelly McNamee, and all of the members and staff of this committee for their hard work, and with best wishes for what I know will be fruitful years to come. So thank you very much, and I'll ask if there are any questions.
Thank you for that report, Michael. Are there any questions for Michael with respect to his report? I do hope my features are working, but I don't see any hands raised. Michael, the reward for doing such an excellent job is that no one has questions. You've done a fine job of answering all the questions that we would have had, I presume. So Michael, I want to thank you for the good work of your committee. And I also want to take the opportunity to thank NYSBA Communications and Publications staff, which continues to do great work in helping us to get the message out there that we want to be seen day after day. All right, again, thank you, Michael. All right, next I want to move on to a number of administrative items. One matter that is important that we cover is with respect to delegates to the ABA House of Delegates. New York State Bar Association has a total of 11 delegates. Only 5 positions are to be filled in April. If elected, the candidates will serve for a 2-year term commencing at the conclusion of the ABA's annual meeting in August. Our bylaws require that the names of the candidates be announced at the House meeting immediately preceding that at which the election will be held. That means we have to mention it today. The nominees are Claire Gutekunst, past president, Scott Carson, and past presidents Bernice Lieber and Michael Miller, and Secretary Sherry Levin Wallach. So those will be our nominees, and we will again be asked to elect them at a later point in time. All right, with respect to new business, is there any new business? Is there any new business? All right, I see a number of hands up. Steve Younger, Michael Getnick, and Mark Alcott, past presidents. Past President Younger, are you with us?
Thank you, Mr. Chair.
Thank you, Mr. Younger.
I would just like to speak on some new issues with regard to the lease in the Bar Center.
Okay.
And I speak on behalf of many past presidents, many of whom are former Bar Foundation presidents and directors. As past presidents of the association, many of us are concerned about the direction of our lease discussions. I heard today that there was a commitment to work together between the State Bar and the Foundation. I applaud that, and I think my fellow past presidents do as well. The One Elk Street property we reside in has been our home for almost 50 years. And we are stewards of this historic property. We inherited it from our predecessors. The Bar presidents and Bar Foundation presidents who spent many, many hours, many years to raise $25 million in today's dollars to buy the property, expand it, and redevelop it. We have spent, and I appreciated Sandra Rivera's report, over $40 million over the years we've invested in the property that we don't own. And any suggestion that one would walk away from $40 million without considering all the options, just would not be a prudent decision. Could you imagine the Court of Appeals walking away from its historic building just because it could lease space down the street for cheaper? And by the way, I will address this because I don't think it's actually cheaper. We have told, as past presidents, our leadership of both the State Bar and the Foundation, that we're happy, as many past presidents did in the past, to join in an effort to raise money for this endeavor if and when there is a commitment to stay in the Bar Center. That's how things were done in the past, and that's how it should be done in the future. But there were a lot of questions and a lot of information that's been raised over the last week. And unfortunately, I think the House received almost the same memo that they received a week ago. So I'd like to go over some pieces of information. This is purely factual that was not addressed either in the memo or the presentation. One, who paid for the building? We as members did. Our law firms did. Foundations like the Cromwell Foundation. And we have rooms named for those people, the Pecks, the Cromwells, our law firms. Can we just tell those people we're walking away from the money they put in? What is the history? Governors Throop, Governor Hunt, Governor Seymour all lived here. Governor Van Buren owned 4 Elk Street and lived there when he was a state senator. There are lots of historic preservation credits and grants that could help us. I haven't heard that anybody's explored those things, and history is a key issue that we need to consider. So let's talk about costs. I asked the committee to do an apples to apples comparison, and we don't have the information yet. We were given this $1 million figure again today. But what does it include? It includes legal fees. They're not maintenance. It includes a rent appraisal. That's not maintenance. So there are numbers in there that's not truly reflective of the cost of continuing the building. There's also in there insurance, $75,000, utilities, $150,000. Has anybody thought about greening our building? Having solar panels on the top to reduce that cost. But by the way, that $200,000 will still be spent, maybe at a different number, if we move. So there's a number in the report of $650,000 for moving. That's not the cost. It's at least $850,000 a year if you add in utilities, insurance, and cleaning and all the other expenses, not to mention the moving costs. So the difference between 1.1 and 850 or 900,000 isn't that big a difference. But as any real estate professional will tell you, real estate is analyzed on a per square footage basis. Anybody who's rented office space knows you rent for per square feet. We have 60,000 square feet at Elk Street. So let's just assume it is $1 million. Do the math. You can all do it on your home calculators. That's $17 per square foot. I asked what the square footage was for the $650,000 number in the report. It's 23 to 25,000 square feet. That's $26 to $28 per square foot. Far more to move per square foot than to stay where we are. That number isn't in the report. It hasn't been analyzed. But more importantly, think about your own home. I know, Mr. Brown, you could afford $1 million house. So you live in a 4-bedroom house costing you $1 million. You can buy a house for $500,000, but it's a 2-bedroom house. So this is all about footprint. So I want to get into the footprint. We have 60,000. Can I just finish, please? I'm almost done.
Steve, if you can please wrap up.
We have
Please.
60,000 square feet at the State Bar. And I'm told by State Bar leadership, we don't need 60,000 square feet, which, makes a lot of sense. So what have we looked at? Have we looked at condoing it, leasing it, getting a property manager, getting a developer, using it for legal aid or a public interest organization? How about a WeWorks in part of the space that would allow local lawyers to be 1 foot from the courthouse? These are all things that I've raised with our committee. I haven't heard anything about them, and I really think it's important. So, one more thing that is critical. There was a $6 million number that includes a grand entrance on Eagle Street we don't need. The real number is 2.6 million, but it's really hasn't been put out to bid. It'll cost us more like 2 million. We can get a mortgage. The State Bar has $36 million in reserves. No one's saying to spend those, but that's our credit. Has anybody gone and seen what interest rates would be to get a $2 million loan? We have $4 million in section reserves. Has anybody asked the sections if they would help contribute to renovating? Has anybody asked the environmental law section if they would help study the process of greening the building? One last factual point. There's a number in the report, which I asked about, that the building's only worth $3.2 million. That's just not correct. That's the tax assessment. Nobody has gotten an appraisal, so far as I understand. Nobody knows what the building's really worth. So on behalf of the former presidents, I say we don't have the information. We need to find out the information. We need to think creatively. We need to explore all the options. And most importantly, do what any real estate person would do. Consult professionals. I would love to hear a report from appraisers, from property managers, from possible development consultants, engineers, the tax issues. We haven't heard those things. And so I really encourage you to explore all available options and to share the questions that our members raise, to share the answers, so we can all have the information. And again, we commend you for this commitment that we heard about today, to take all necessary steps to explore all options, because we really shouldn't leave this beautiful historic building without doing so. It would be a shame to our forefathers and our foremothers if we did that. Thank you.
Thank you, Past President Younger. I'm going to say again, we have to limit comments and questions. We are a new business. And if everyone is going to speak at great length, it's going to get us into real trouble. I will say, in fairness to the Facilities Committee, I know that many of the issues that Mr. Younger has raised are important issues, and I thank you, Steve, for raising them. I do know that our committee is looking at them, and I believe every issue that you mentioned has either been looked at or is in the process of being looked at. And today I asked David Miranda and his committee just to give a brief update, even knowing that all the answers to all the questions have not been fully analyzed so as to be addressed here today, but I did think it was important that we be kept abreast. All right, who is next? I believe Don Dorr is next, to be followed by Hermes Fernandez.
And you gotta unmute yourself.
Is Don Dorr with
I
us?
unmuted it and
Oh,
it's
there you go.
muted. Sorry about
Thank
that.
you.
It's just so you know, it takes a while to reboot when you're brought on as a speaker.
Okay.
So that's why the pause. But hey, I just wanted to say something really quickly that I just thought of. As we're going to find out, the members of the House are the members of the foundation. With full disclosure, I'm a member of the House and I'm a member of the board of directors of the foundation. For whatever reason, and there are many, this has become somewhat of an adversarial thing. And I just want to point out to everyone here today, there's been some great progress made in the last week. And I think that both boards, the foundation board is just finding out about some of these things for the first time and really hasn't had time to discuss it yet. I know that there have been some very fruitful meetings, meaningful meetings. And I just think that everyone at this point should keep an open mind and let the leaders of both organizations, and let's face it, the Bar Association and the Bar Foundation are joined at the hip for many reasons, for many good reasons. And they've had a 40-year relationship. So I think that over the next coming weeks and months, I think a lot of good can be made, but just remember that we are all both members of both organizations, whether we like it or not. So I think we can really make some progress here and have some discussion that's going to lead to the right decision for all involved. Thank you.
Andrew, you're muted.
All right, thanks, Tom. We will now have past President Mark Alcott to be followed by past President Mike Getnick.
Thank you, Mr. Chair. I endorse the remarks of Steve Younger and of Donald Dorr, but that's not what I'm going to talk about. I'm wearing my curmudgeon hat. I should begin by saying I have enormous respect for our leaders, for all the prior speakers. Please don't take this remark I'm about to make as anything personal. It's not. But could we please do away with the term NYSBA? It's a guttural, frankly, terrible sounding word. It has no meaning to anybody outside a very narrow group of ours. We've gotten along without it for more than a century. We have a very proud name. We are the New York State Bar Association. If that's too many words to fit within your remarks, you can call us the State Bar or the Bar Association or the Association. But I hope we will not start calling ourselves by a nickname which doesn't express anything, doesn't show anything, and I really find it to be worse than useless. Thank you for listening to me.
Thank you, past President Mark Alcott, past president of the New York State Bar Association. Next, I'd like to call on past President Mike Getnick.
Okay, I think I'm unmuted.
Yes, you are.
I think this is very important, and not just for the trial attorneys on the House of Delegates, but for anybody who has trial attorneys in their law office. Yesterday, and I don't want to give a lot of credit to what might be considered a competing organization, but the New York State Academy of Trial Lawyers for free put on a very, very important program. Very well attended by thousands of people. I'm not sure if it got over to 4,000 people or not. And I don't know about the rest of you, but I was not aware of the complete change in rules that have now come down for the uniform rules and pursuant to an administrative order. If you're not aware of this and don't follow these rules, you may as well not be practicing as a trial attorney. And I'll make it short. Any of us who have practiced in federal court would be somewhat familiar with these rules. They relate to discovery, to filings, to motions with limitations, what's required of the lawyers. I'll be very honest, as far as I'm concerned, these new rules make it very easy for the judges, but very, very difficult for the attorneys. And so I think that the officers and the executive committee should look at with CLE to see if a similar program should be put on. The speakers were fantastic. Most of us know Lucille Fontana. She's certainly a member of the New York State Bar Association. I'm not sure if David Horowitz is or is not. They did the program. They only had an hour. You can't teach all of the changes in the rules, but it's enough to scare you to realize that if you don't understand these rules, you're going to have to stop practicing law. It's just a total change from what we are used to. And from my experience in federal court, as I said, it's going to be very, very difficult for lawyers if you have disputes with your opponents, and very, very much easier for the judges. So everybody should be aware of it. I think one of the matters is an administrative order, and I forget the particular number, but it's the whole change for the uniform rules. So again, I just want to alert everybody. Maybe some of you are already aware of this, but I really think the bar, if for new business, this should be looked at immediately. Thank you very much for your time. Thank you, Andrew.
Thank you, past President. Now I'd like to call on Hermes Fernandez to be followed by past President Justin Bigdor.
Thank you, President-elect Brown. I simply want to comment quickly on the questions regarding our building. I hold the building in great affection. I've spent much of my time with the State Bar Association in that building. But I do believe that whatever decision is made, and I'm not advocating for any decision at this time, whatever decision is made must be made based upon what's in the best interest of the Bar Association going forward. We certainly need to salute the past, respect the past, but we must plan for the future. I can say as a member of the health law section that there are very few members of the section who have spent any time at all in the Bar Center. For the members of the health law section, they're as familiar with the Marriott Hotel or the Hilton Hotel as the place of business for the State Bar Association as any other facility, and probably more so than the Bar Center. All things being equal, I'd love to stay at the Bar Center, but we must be planning for the future. Thank you.
Thank you, Hermes. I would like to call on past President Justin Bigdor. Justin, are you with us? Please unmute, Justin. Justin, please unmute. Past President Justin Bigdor of the New York State Bar Association, please unmute.
Video.
Where was it? Justin, there you go. You're good.
Okay. Thank you.
Thank you.
Thank you. I will speak very briefly as past president, not only of this association, but also of the New York Bar Foundation. I endorse completely all of the remarks of Steve Younger and Don Dorr. And I know that the committee and the House of Delegates will be very, very careful in making that very fundamental decision. But I do think that all things considered, there should be a bias in favor of working and remaining with the present historic structure. I know that there are many, many economic issues that must be considered, but I really believe we have a tremendous investment there, both in dollars and in the intangibles that that building represents. I don't want to take up any more time, but thank you for this opportunity, Andrew.
Thank you, past President Vigdor. All right, that concludes our new business today, and I believe it puts us more or less right on time. We were scheduled to finish at noon, and it is 11:59. I want to thank you all.
Excuse me, Mr. Chair.
Yes. Yes, Sherry?
Sorry, this is Sherry Levin-Wallace. There was a reminder that we were asked to provide from the Diversity and Inclusion Committee. Would you like me to go ahead and do that?
Sure, please.
I'm
Yeah,
sorry to
please.
interrupt, but
Yes,
the Diversity and Inclusion Committee would like to remind everyone that the 28th-day Racial Equity Challenge is coinciding with Black History Month and will begin on February 1st. The NYSBA landing page will go out live on February 1st, and you'll be able to participate. Thank you very much, and thank you, Mr. Chair.
Thank you, Madam Secretary, and I'm glad that you did mention that. That is something that I wholly endorse, and hopefully all of you will get behind it. Our next meeting will be on April 10th, and that will, of course, be a remote meeting. And I know that we look forward to having meetings in person, and that day will come. Our business is done here. I will entertain a motion to adjourn.
So moved.
There's been a motion. Is there a second?
Second.
It's been seconded. I guess we need a poll to be official. Please vote. So far, the nays have it, so be sure to vote, or we're going to continue to be here for a while. Okay. I believe that.
I mean, would that mean we'd have to stay here forever?
Perhaps we all love this building so much, so we don't ever want to leave. All right. The motion carries. There is one abstention, which is interesting. All right, ladies and gentlemen, again, thank you so much for joining us today. It's a challenge sometimes conducting meetings virtually, but we've all gotten used to it. And I want to thank each of you for continuing to be committed to carrying out the important business of our association. And with that being said, in concluding the House of Delegates meeting, I now want to call upon my friend Leslie Rosenthal, President of the New York Bar Foundation, who will preside at the annual meeting of the foundation. And Leslie, and to the members of the foundation and to the members of the House, you can stay right on this line. We don't have to get off and get on another call as we did earlier today when switching meetings. Thank you. Leslie?
Thank you so much, Mr. Chairman. So much appreciate the importance of what the association and the foundation do together. We very much appreciate what the lease negotiating teams are doing, what the association's finance committee is doing. We just wanted to reaffirm we are in this together. We want to be helpful, working together in continuation of a long, valuable relationship to continue to build upon our synergies, fully realizing efficiencies and economies of scale, honoring our history and charting our future. My fellow foundation officers and I continue to request and would welcome the opportunity to meet with our counterparts at the association so that we may arrive together at an agreed upon set of facts and a resolution of the lease negotiation that will benefit both organizations. There was a meeting of the House last week at which the association presented its point of view. A number of members subsequently asked for the opportunity to hear from the foundation, and we would of course welcome the opportunity to provide that information that's been requested regarding the building, operating matters, tax matters, overhead matters, grant matters, and so forth, and to address the House on these important matters. I would now like to call the annual meeting of the New York Bar Foundation to order. The members of the House of Delegates has been noted, also serve as members of the New York Bar Foundation. And I would like to ask you now to take a look at the minutes of the annual meeting of the foundation from January 2020 that have been distributed. Ask if there have been any corrections, and if not, if we may have a motion to approve the minutes of our January 2020 annual meeting as distributed. Is there a second? Thank you. All those in favor, please say aye.
Aye.
Any opposed? The motion carries. Thank you. Under the foundation's bylaws, the members of the House are the members of the foundation and are also the lifeblood of the foundation. We deeply appreciate your support. For those who have become fellows of the foundation, we're so grateful for your engagement, whether you're a new fellow, a life fellow, or have chosen to move into one of the higher circles of giving. The annual report of the foundation in your materials, and in light of the hour, I will just highlight a few key points from our 2020 year. We allocated more than $750,000 in grants to 138 grantees all across the state, including our annual grant program to innovative legal services providers, providing access to justice for the least fortunate among us. Through our annual grant making and our special purpose fundraising, we have also distributed grants for COVID-19 emergency legal relief, as well as assisted veterans of the U.S. Armed Forces in need. Through these grants, 100,000 New Yorkers gained access to justice, and over 5.5 million of our neighbors were beneficially impacted. Among these were victims of COVID-19, both the pandemic and the associated economic fallout, as well as worthy legal services programs assisting many across the state. I would invite you to turn to page 35 of our annual report to see the distribution of these grants throughout the judicial districts in our state. While the pandemic ravaged the summer plans of so many law students across the state, the foundation followed through with $236,000 of funded scholarships and fellowships, benefiting 82 students and law-related organizations. Many of these summer fellowships were funded by our sections, and we thank you. Also among them were 60 Catalyst Public Service Fellowships, inspired by Chief Judge DeFiore and matched by every law school in the state. In our call to action report on racial justice, the foundation researched the connections between racial justice and the rule of law. Spurred by the killings of George Floyd, Breonna Taylor, and far too many others, the foundation has committed to investing in organizations tackling racism in a systematic and sustained way. We've been in touch with Association Task Force co-chairs Andrew Brown and Taya Grays, so that the foundation and association may work in a coordinated fashion to disrupt the forces of racial injustice and heal our national divide. On the topic of women and access to justice, and in celebration of the centenary of women's suffrage at the 2020 Second Circuit Judicial Conference, on behalf of the foundation, I had the privilege of highlighting the foundation's work in funding access to justice programs assisting women, including in human trafficking cases, family law matters, and immigration law matters. May we have a motion, please, to ratify and confirm the actions of the Board of Directors since the 2020 annual meeting?
So moved.
Thank you. And a second?
Second.
Thank you. All those in favor, please say aye.
Aye.
Any opposed? And the motion carries. On the topic of support, I want to recognize the sponsors of our virtual Fellows Dinner last evening, a celebration of our fellowship even in this moment when we are apart. The theme of our evening was the Roaring Twenties, with high-spirited though low-budget entertainment. And on that 1920s theme, I would like to express our thanks to our dinner sponsors, the Highball sponsors, William and Holly Russell, the Bee's Knees sponsor, Franchina Law Group, and the Hanky Panky sponsors, Farrell Fritz, Donald C. Christ, John Horan, Ralph Nappy, John Nona, Jessica Parker, and Roger Tillis. The next item on the agenda is the report of the officers, which will, I'm sorry, of the nominating committee, which will be presented by David Schraver, the chair of our nominating committee. Over to you, Dave.
Dave, you're muted.
Good afternoon, everyone. I have the privilege of chairing the nominating committee of the foundation. The following individuals who are members of the New York State Bar Association have been nominated as directors of the foundation for a 3-year term commencing June 1, 2021 and ending May 31, 2024. They are Vincent E. Doyle of Buffalo and Lauren E. Sharkey of Schenectady. I understand that their bios have been distributed as part of the materials for this meeting, and I move their election. Is there a second?
Second.
Do we have a poll for this election?
I think we're taking a voice vote, Mr. Nominating Committee Chairman.
All right. Then all in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? All right. It appears that the motion carries. And thank you very much.
Thank you so much, Dave, for your service on the nominating committee, as well as the lease negotiating committee. We're so grateful to you for your perspectives and your dedication. Unless there is any other business that anyone would like to raise, I would like to entertain a motion to adjourn.
So moved.
Second.
And I thank you very much for your attention, and we stand adjourned.
Thank you, Leslie.
Thank you, Leslie, and thank you for a beautiful evening last night. It was extraordinary.
I think